You good? Pardon me? Yeah, meaning the staff attorney there can screen whatever. What is it?
We have two people, you just pay.
Yeah. So, his staff attorney is a guy named Wesley. So just like you would with Monica, here's the materials and you can figure out if it's an easy signature, he can bring it in here because we'll be here for a little bit. Will you let me know when you're ready? Great. Pardon me? You're ready? Great. All right. Well, let's get on the record. This is 24CV010646. Awa Best Braids versus the City of South Fulton. And I want to cover a few procedural things before we dive in, but why don't we start by getting the appearances. Let's start for petitioner / plaintiffs.
Your Honor, my name is Renee Flaherty with the Institute for Justice.
Will you be the primary spokesperson today, or do we have a quartet?
No, it's me.
Okay, great. How do you pronounce your client's last name?
Awa Diagne.
That's all one last name?
Awa's her first name.
Okay, that's what I thought. So the last name you pronounce?
Diagne.
Diagne. Thank you. All right, and representing the City of South Fulton.
Your Honor, Dana Main, Freeman Mathis and Gary on behalf of South Fulton.
Ms. Main, thank you for being here. I know your colleague had a conflict today and asked that we do this on a different day, but if we didn't do it today, we were probably going to be meeting in December. And these are some pressing matters, so it was important that we meet today. I also recognize that you're playing catch up in part because your colleague may have been lead on this, but also because this is a relatively new matter. And so I'm well aware of that as we work through this, that there have been I won't say all sorts of, but there have been pleadings from, I'm going to say plaintiff. I know it's sort of a dual petition plaintiff, and you haven't had the full amount of time that you normally would to respond. I don't mean to put your client in a disadvantaged place because of that. We can start our discussion today, see how far we can get. If it becomes clear to me that you simply need more time to respond to questions or concerns I have, we'll certainly make that happen.
Thank you, Your Honor.
Sure. All right. So, Ms. Flaherty, you cover the waterfront with what's been filed here. It's a petition for review. There was a decision by the city, as I understand it, and nothing I say you should take as etched in stone. I have tried to digest the record, and as I play it back, both sides should feel free to correct me before we dive into the substance of the dispute. So let me take a step back from that. In a nutshell, I understand the issue to be that Ms. Diagne wants to open. She already has a lease for a storefront in a shopping center in South Fulton where she wants to open a hair braiding business. And for whatever reason, she was told or believed she needed to get a special use permit. And one of the questions we need to work through is, do you even need that for the type of business that Ms. Diagne is trying to operate? Nonetheless, she tried to get one, and the first level review, check, perfect, we like it. And then it goes to the next level review. This is appropriate, let's do it. It gets to the city council, and lo and behold, there is a competitor who doesn't want competition. And there is an email campaign to one, it may have been multiple, but at least one, what I've seen from the record. And everything I'm sharing is in the record. It's not what's happening on South Fulton blogosphere. It's in the record, an email campaign led by Ms. Davis, who is the owner of, I'm going to call it Salon Vibes. And she and her customers and her employees really filled Council Member Willis's inbox with emails saying, you got to think about us and competition. I'm distilling it as competition could be problematic. And that's kind of the record. The vote is 4-3 to deny the special use permit in the face of the findings of the two lower bodies and without any factual findings made at all. 4-3, nope, you don't get it. So one reason we're here is what you styled as a petition for review. Judge, you need to review this if it was some form of zoning decision. Layered on top of that is a series of declaratory judgment actions that I think are being pushed through in terms of jurisdiction. Paragraph 5 of that amendment that was made to the state constitution declaring that what happened was unconstitutional. Or if there is some, I don't know that there is, some ordinance that said too much competition is a basis to deny a license, that would be unconstitutional. I think the record is that there is no such ordinance, despite several council members either wishing there was or mistakenly believing there was. And then finally, failing all that, or on top of all that, injunctive relief, saying you asking me to enjoin the city of South Fulton from taking steps that would be plainly harmful to another set of dreams, the dreams of Ms. Diagne to have her business. That dream shouldn't be viewed as any lesser importance than Salon Vibes dreams, and let her pursue her business. And if that is something that creates competition, you know what? We can't stop Burger King from opening across the street from McDonald's. And I'm not making any ruling. This is just sort of the thrust of the argument as I've read it from you. Is that sort of a fair summary of plaintiff's position?
Yes, Your Honor.
Okay.
That's all exactly right. And as to whether she needs a special use permit at all, they're categorizing her as a beauty salon. You know, for what it's worth, she's a braiding shop and not a beauty salon, but that's the city's position, and I'll let Ms. Fulton speak to that.
Well, we'll talk about that. I have a set of issues that I want to understand from both sides. So we have some funky procedural things we need to work through that are set forth in, I remember if it was the emergency motion, where there's an acknowledgement that, well, you can't really get an injunction when you're seeking declaratory relief through paragraph 5, but you can get an injunction in this other space, and maybe it's not precluded. And so I'm happy to wrestle with that. But where I really wanted to start with you, and then hear from Ms. Main, and then I'll let you move forward from plaintiff side, and then we'll obviously hear from the defendant side. Why is the solution to this not simply, it's a petition for review, it's reversed. There is no basis for denying. There's no record. It was simply denied, and you can't simply get a red stamp that says denied, hit that on a piece of paper and deny it. There have to be findings of fact. In an absence of finding of fact, it is by definition arbitrary and capricious. Denied. You need to grant it, because the only record would be the two lower judicatories saying, yes, it should be approved. And then there's dialogue at the council meeting and there's the email campaign, but there's not what's required under the ordinance of a finding of fact or findings of fact. So we've got instead 4 council members saying no, but not doing what they're obligated by their own laws to do, giving the reviewing court nothing to review. And so the same argument could be made if it was 4-3 to approve, and someone who was unhappy with the approval said that's as arbitrary approval, there are no findings of fact. Maybe one could argue it was simply they adopted the findings of fact of the 2 bodies that had already said, look, it meets all the requirements, and so it ought to go forward. So that's where I want to start, and then you can go where you want to go from there.
If I understood your question, Your Honors, if the court ruled that way, would it,
Why shouldn't I rule that way, and why shouldn't that be it, full stop, and not worry about a declaratory judgment or an injunction? That's sort of the simplest, but it's the one that hits you in the face, hit me in the face as I'm reading through this, is that, and city council people aren't lawyers. I mean, they can be. I don't know that these are. And they are putting the interests of their constituents foremost, which is what they should do. But if it wasn't done the right way and there's nothing to review, I'm just wondering why that's not the way to handle this.
I think that sounds great to me, Your Honor. So long as the reversal involved granting her the permit and her being able to open her shop, that would be great, and that would move everything else.
Do I have the authority to say you must grant it, or do I only have the authority to say, how could I possibly rule on this? You didn't give me any findings of fact.
So Your Honor could reverse with instructions, and that comes from Georgia Code 5-3-18A. Your Honor can affirm, vacate, or reverse, and reverse with instructions. And I think the court could reverse with instructions to issue the special use permit.
Okay. All right. Assuming that's not what happens, where do you want to go next? Before we do that, Ms. Main, I want to make sure that before Ms. Flaherty dives into here's other reasons why you should grant our petition for review or the deck action, et cetera. If any of the things I've described struck you as that's not what the record says, let's clear that up now so I'm not laboring under any real bad misapprehension of sort of how we got to be where we are today.
Your Honor, it's a loaded question. There are some factual issues in terms of findings of fact that we disagree with that I'm happy to go into with the court.
Mm-hmm.
But sort of getting back to let me go back to the beginning. I believe what the court led with in terms of what we can do here under a petition for review, I believe that we should stop there. And we get to the same place. And Your Honor, that is one of the reasons why I'm not displeased that I had to stand in Mr. Klein's shoes today, because I do want to bring this to a conclusion one way or another. And I believe that the court can do that with the petition for review. And I believe that that is the appropriate and the only route for the court to take.
Okay. Well, why don't we stay focused on that, at least initially, when I hear back from Ms. Flaherty. But tell me what you think I was either I hadn't found yet in looking through the record or had misapprehended. And it wasn't meant to be a loaded question. I try to start hearings by saying, I think this is what's going on, and then ask for that immediate feedback so it doesn't cement into place, because if the way I think things are, what the record shows is favorable to the side that goes first, they just, great, don't change your mind on that. And I haven't decided anything yet.
Yes, Your Honor. In terms of a couple things about the in writing, first of all, I mean, it's not required to be in writing, the findings of fact.
Mm-hmm.
And we would submit the findings of fact. There are findings of fact that were in the two recommending bodies. They're not, they don't go up by appeal. They're just, staff makes a recommendation and then the planning commission makes a recommendation. And
Right.
both of those had findings of fact.
Yeah.
And then the city, but they don't consider everything and they're not in the same position.
Who doesn't consider everything? The staff and the planning commission?
Yes, sir.
Okay.
Yes, Your Honor. And so then the city council and the council members are in a different position than the other two bodies are. And Your Honor, we did a supplemental filing in terms of the record at the request of the plaintiffs.
And Ms. Niles flagged that, and I think it's in my folder right here. So.
And there, Your Honor, you're not going to find a findings of fact in that supplement.
Okay.
Your Honor, I did, and I don't know if it's gotten filed or where it is. We've got the comprehensive plan, which is got the zoning ordinance. The comprehensive plan is adopted through the zoning ordinance, and then through that, you've got a document. Sorry, Your Honor.
And I know that's one of the standards. In fact, that's standard number one, is the proposal consistent with the comprehensive plan. It's capitalized, so it must be an important plan. But I bet the comprehensive plan doesn't say stamp out competition.
It absolutely does not say stamp out competition, but it is in the opposite. And so, Your Honor, I know that is how the stamp out competition, I know that that's how it's been framed.
Right.
But the fact is that the issue is a concentration of uses. In the comprehensive plan, and I've got copies that I can give the court, and also they are in the process of being filed. They're large documents, so there's some difficulty my office doing it. There is an economic development strategic plan that was adopted as part of the comprehensive plan.
So I think I don't know that I have it. I have a 207-page filing that came today. Would that have what you're holding in your hands?
It does not. That's the zoning ordinance, and then these are two that the zoning ordinance adopts the comp plan, and the comp plan is part of this economic development test or study that's done.
Okay.
And the council member who spoke and Your Honor, I believe that the video, did we successfully file, if we successfully filed the videos?
A placeholder for it, so
Were they not?
that I don't know.
Okay. Your Honor, I think we need to, for the court's purpose, both of the planning commission and the city council meeting were videoed. And
There is page 54 of the record says YouTube link placeholder for video recording of the July 9th and July 23rd meetings. So I don't know if that's a link I can click on for later consumption or how that'll work. But that's one way South Fulton makes a record, is that it, okay.
Yes, Your Honor. And if we could with the court, if the court doesn't make a ruling from the bench today.
I'm not making a ruling from the bench today.
Thank you, Your Honor. If we could, then we'll come to an agreement with the court about what format. But we have referenced to the court, it was on Councilwoman Willis, who was the one who made the comments about the concentration of uses and the economic development purpose behind not wanting to have a concentration of uses. And this one shopping center has a beauty supply store, and it has a beauty shop, and then it has what we maintain, the hair braiding is a subset of the beauty shop. Beauty shop does hair braiding, and but the plaintiff in this case does just hair braiding and not the full services. But Your Honor, and Councilwoman Willis was intimately involved with coming up with a comprehensive plan, voting on it, and involved in all of the meetings. And as she says on what we consider to be the record, that they have been working very, very hard since the city was established to have a diversity of retail, and that this concentration of uses goes against their attempt at creating the diversity. And Your Honor, we have cited in our brief, we had cited to different pages in those two documents that refer to that concept.
The two documents meaning the two YouTubes, or the two documents meaning the comprehensive plan?
Well, Your Honor, both.
Okay.
We cite to where it is in the transcript, or not transcript, where it is in the video and at both meetings. And then we also cite to where it is in the comprehensive plan and in the economic development strategic plan.
Those are two different things.
Yes, Your Honor, and it's the zoning ordinance it references and adopts the comprehensive plan, which has as part of it the economic development strategic plan. And all of these were done at the beginning when the city was being formed. So Councilwoman Willis explains how they've been working. They inherited from Fulton County what she considers to be somewhat of a mess in terms of creating a vibrant society with a mix of retail uses. And that is what she said, all that citizens have been asking for it, and that has been a problem. And again, it's cited in these documents that were the strategic plan was finalized in June of 20, and the comprehensive plan was finalized in November of 21. So these predate the plaintiff's petition in this case.
Sure.
And so
I would have to, because I shouldn't have to, but almost everything ought to predate this application. This all happened very recently.
Yes, Your Honor.
And it would be particularly problematic if this notion of we want to avoid economic saturation came up only after the application. I assume everything that Councilmember Willis is pointing to would be things that were some of the genesis of the city of South Fulton, which itself is fairly young.
Yes, Your Honor. It's very, very new.
Okay.
So, Your Honor, those are from what the court had said. That is.
But how do I figure out what the decisions rely, well, let me put it differently. Per the city's own ordinances, this is 80403. Following the public hearing, there were two of those. The city shall adopt findings of fact. How do I know what was adopted? And is it just wherever sides wins the vote, the record becomes findings of fact? And if that's findings of fact, if a city council member, all I need to do is give me the microphone and I'll create a great record. That doesn't mean it's fact, and it doesn't mean anyone found that fact. I just happen to be on the winning side. So I'm struggling a little bit to, that phrase findings of fact means something to you, given what you practice and where you practice. And it doesn't typically mean see everything, because presumably there were voices of the three who voted in favor of this application that could also be findings of fact, maybe not of the majority, but I don't know. So I'm not sure what you're pointing me towards as what would constitute the findings of fact.
Your Honor, there are a couple of responses to that as immediate. I mean, I've been doing land use for several years.
Mm-hmm.
And for special use permits or conditional use permits, there is no requirement in case law or in statute that you have findings of fact. And in fact, I have never worked with an ordinance that included that phrase.
But this one does.
But this one does, but it is not. So if we were here today, we would be doing, I mean, we were with an ordinance like the others I've been using for 30 years. Those don't, they may exist out there, but this is the first one I've ever had. What you do is the facts are in the record. And yes, Your Honor, I will go to the record and look for facts that support either the approval or the denial, whichever one is being challenged. And Your Honor, there are findings of fact that were written by the staff originally, and then those went up. The staff in terms of, there was not any disagreement. The staff with reference to the comprehensive plan said, and it had to do with, Your Honor, comprehensive plan or economic plans, that one they said they didn't know, or that they might have answered a no to that, Your Honor. I'm sorry for. Your Honor, in the record, it's on the records on page 45 of the staff report. It says number 2 is the proposed use consistent with the supplemental plans adopted by the city council, such as revitalization or economic development plans. And the answer is not to staff's knowledge. So, Your Honor, that is a finding of fact of sorts, but Your Honor, with which it does not appear the city council would have a disagreement. But Your Honor, yes, we would go back to the statements that council member Willis made at both the hearing, the original hearing, and then at the hearing at the meeting where she voted. They all voted.
Is this shopping center in District 3?
Yes, Your Honor.
Okay. Other things you wanted to help me understand about maybe the structure of the process in South Fulton. This was helpful to learn, one, that this notion of findings of fact is kind of new and different for you. I need to explain to folks, I'm presiding today for another judge. And so Deputy Gordon may from time to time appear saying, hey, could you sign something? And we'll pause what we're doing so I can do that. But were there other things that you thought I ought to understand about the kind of process flow of this getting from application for special use permit all the way to the city council's 4-3 vote?
I don't believe so at this
denying.
point.
Okay. All right. Then let me turn back after we do this. Hold on 1 second. All right, Ms. Flaherty, whenever you're ready.
Absolutely, Your Honor.
Thanks.
First of all, I agree with Your Honor that there don't seem to be any findings of fact that the city council enacted, and they were supposed to do that. But to the extent that they adopted the zoning staff's findings of fact, then we would still win, and Your Honor should still reverse the decision, because then there's insufficient evidence in the record that the city did this for any reason but protectionism.
What about Ms. Main's point that a council person is saying things on the record and saying, I find that this license issuance, if issued, would be inconsistent with the economic development strategic plan? That's part of the record. It's not something that I might normally view as findings of fact, but the city made its own bed, and its own ordinance says you'll issue findings of fact. You will adopt. It doesn't say issue, it says adopt, but they'll adopt findings of fact. And so maybe when they voted 4-3, they're adopting the record that was made, which problematically, I think, for the city includes the findings of fact of the staff and of the planning commission. But to Ms. Main's point, wouldn't it also include whatever record was made that I would gather by watching the 2 YouTube recordings?
Ultimately, Your Honor, I don't think that matters, because taken all together, the record is still completely insufficient, and still requires reversal, and, the one,
What's insufficient about, and I haven't watched it yet, I'm relying on Ms. Main here saying that Councilmember Willis may have provided some pretty insightful commentary on we are trying to build a city that allows for growth in many places and doesn't end up with all the fast food restaurants on fast food row and all the liquor stores on liquor row. And it is spread out so that if you're in one part of town, you can knock out 4 errands rather than having to go way over here to get your hair done and then 4 miles over there to get your tires changed. Assuming something like that is in the record, why wouldn't that be, given what my review is, if this is a petition for review, that might not seem super compelling to you, but that's not the test, whether Ms. Flaherty was overwhelmed by the analysis. It would be, there's a reason that's not arbitrary, that we are seeking to smooth out the presence of different forms of retail throughout the appropriately zoned. So we're not going to put a gas station in the middle of cul-de-sac, but just sort of smooth it out around the city of South Fulton.
2 responses to that, Your Honor. I think that economic development is just sort of another way to say protectionism. It's just sort of a thing we hear. But even if it weren't, economic development is not a legitimate health and safety reason for zoning. Zoning is more like, don't put the gas station in the cul-de-sac, don't put the chemical plant next to the elementary school. And the one thing Your Honor didn't mention at the beginning was the case Raffensperger versus Jackson. And that's just last year, the Supreme Court of Georgia said that protectionism is not a legitimate reason to interfere with someone's right to earn a living in the occupation of their choice. And not only did the court say that, but they said that if there is a different reason, it has to be a legitimate health and safety reason. And the government's action has to be reasonably necessary to further that legitimate interest. And that's absolutely not what we have here. Just some sort of broad economic development rationale is not a real health and safety reason to interfere with always very, very important right to earn a living in your occupation of your choice.
Okay. What else do you want to tell me about granting the petition for review?
The only thing I can think of, Your Honor, is that the links to the videos are also in our briefs. If the record is a little bit cumbersome.
I mean, it's not, I just need there's the link so I can cut it and paste it, and presumably I don't need a secret South Fulton code to get in. It's public.
Publicly available on YouTube.
For all late night viewers.
Exactly.
All right.
Password.
YouTube is a powerful space, I can tell you. Let me see if I had other questions. Do I even need to tangle with the question of whether a special use permit was required? Or should I just take head on, you know what, we did one anyway, and the issue here is that it was improperly denied? As opposed to saying, Ms. Diagne shouldn't have been put through the special, it sounds like she put herself through it, but I don't know the origins. I don't want you to get into things that aren't in the record. If she said, I'm opening, and then the ordinance police showed up and said, you can't open without a special use permit. And instead of saying, well, wait, look, I don't use chemicals or whatever would trigger the special use permit requirement. She said, okay, I want this to go smoothly. Tell me what I need to apply for, and I'll do it.
Well, I don't think any of that is in the record.
Okay.
Insofar as we do have an equal protection claim in our deck action that says that she shouldn't have had to get a special use permit because there are comparable businesses that don't.
Right. I think that's a great argument if we have to get over in that space. But it's not in the record as to why she applied for a special use permit.
That's correct.
Okay. All right. And we won't tangle with that. Okay, those were the questions I had for you in that space. So why don't I turn to Ms. Main, and then maybe that's where we stop for now, and it may be that we have a conversation a bit about the declaratory judgment or the injunctive relief part. I will very much want to get input from both sides about when, whatever is happening next, given that for the very same reason people are passionate about ensuring that Salon Vibes prospers. We have someone who has invested money and has potential employees who want to get started and is stymied right now. So I think time is of the essence for everyone. Not ruling from the bench, like I said, but I'll very much want to understand if we think what's next is X, what's the time frame? And one reason why I'm flagging that is it's not this case, but I often have a situation where someone says, oh, sure, we'll send it back to the city, but they don't meet on zoning matters again until April. And that's not how we would need this to work, because then it would be sent back in a different way. But Ms. Main, tell me your thoughts, because you said, I think you're right. We need to handle this just through the petition for review angle.
I do think that that is the only thing that the court can do. I don't think that there is jurisdiction to do anything else. We have an adequate remedy at law. That's what we're doing here. I will also point out, Your Honor, that to the extent that there is a constitutional challenge, there was a constitutional letter that was sent to the city, but in footnote 1 of that letter, it says.
What's a constitutional letter?
Your Honor, in order to bring a constitutional challenge to this court, that challenge has to have been lodged below when you're up on a petition for review.
Oh.
So you had to have made a constitutional challenge, the applicant does. There is a letter that sets out, it's from what is now plaintiff's counsel, a letter that sets out some concerns. But in in footnote 1, they admit that they're not representing Ms. Awa. And so it says, we just learned of this matter late last week and do not currently represent Awa. So Your Honor, so the concept of this court being able to rule on a constitutional matter, it cannot. I don't think the court needs to rule on a constitutional matter. In fact, there is the first petition for review would get the plaintiffs to where they want to go in that direction if that's what the court rules. And so I don't think that there is any harm one way or another, but the fact is that the applicant herself, and we've got, and Your Honor, we did not raise this issue, but we've got an individual and then we've got a company. And for purposes of what we're doing here today, again, to expedite the resolution of this matter, we have not gone into that. But one of them does not have standing, Your Honor, but that's not relevant.
Okay, but appreciate you flagging that, because I noticed we've got both here. So either way.
Yeah, Your Honor, and that, again, we like the plaintiffs would like to have a resolution and an expedient resolution one way or another.
Okay.
With this matter. So Your Honor, but that's why in terms of what's in the record is significant, and the decisions that can be made through the petition for review are before this court. Your Honor, we had filed a responsive brief earlier today, and we do address Raffensperger as pointing out that it has to do with the regulation of a class of occupation. And that is not, no one in the city zoning ordinance does not say you can't be here. City zoning ordinances all the time have separation requirements. They have.
What's a separation requirement?
If you've got a liquor store, you can't have another liquor store for 500 feet or 500 yards. You can't have a liquor store here. You can't have a liquor store near a church. You can't have, there are other uses that they say you can have a separation requirement for fast food restaurants. You can have separation requirements for gas stations. You can have separate. So Your Honor, And one may say, oh, that's not fair. The city likes Quick Trips and they don't like Exxon. Your Honor, and.
So there's case law that would support the validity of separation requirements.
Yes,
That's in your brief?
that is not in our brief. I will get that to you today.
That would be great. But that's what that separation requirement doesn't mean when you're firing someone from the city government. It is exactly what you said, that only one liquor store every 3 blocks on the main thoroughfare.
Yes.
And that can apply to sin tax businesses like fast foods, or I don't mean to suggest they're saintly, but I know there is funky zoning about you can't have insurrection near a school, and that would make sense for liquor store. When you're dealing with hair braiding, that would seem like it is interfering more economically and less of we don't want a liquor store right next to the high school. I get that.
But Your Honor, the separation in this isn't, and it is a special use permit process. And the special use permit process says, we know there are some uses that are going to be appropriate in these districts, and sometimes they're not going to be appropriate. And what went into, now I can't, it's not in the record, I can't tell you why the city had special use permit for this particular use, but there is no doubt that they have, it is a special use permit that says when it comes up in front of us, we are going to look at it on a case-by-case basis. The concept of a special use permit is well recognized in law. It's in the CPL, it's in case law. There is no issue about a special use permit.
No, I didn't hear plaintiff saying the idea of a special use permit is a bad thing. There is a question of whether Ms. Diagne needed one, but that's not before me because she applied for one. I guess she could try opening up, saying, I don't have to have one, and that's a different challenge, and see what happens there. But she tried to follow the procedure that someone told her she should follow. So I'm not pushing back on the idea of the special use permit. It doesn't jump out in reading about the factors to be considered that separation is one of the factors, other than that they're generic or exceedingly broad things like, is it consistent with the comprehensive plan? But that could be a great catch-all if the comprehensive plan focuses on the value to the South Fulton community of avoiding concentration. I don't know.
Yeah, yes, Your Honor, but avoiding concentration is, I mean, every time you have a special use permit, you're going on a qualitative analysis of that use in that location and the factors that go into that, Your Honor. And I certainly, you have, and I know hair braiding is not like this, but the example that I have dealt with the most are rock quarries. Sometimes they're going to be in a place that's appropriate, and sometimes they're not. And sometimes you're going to be up against Vulcan, and sometimes you're not. And so each time there is a qualitative analysis that goes into each location. So, Your Honor, and that is what happened.
Qualitative sounds like a euphemism for subjective.
I understand why the court believes that there's going to be some subjectivity to that analysis. There has to be, because that's the concept of a special use permit. Otherwise, if it weren't allowed to be subjective, you wouldn't be allowed to have it, because that's the whole point.
Because there'd be nothing special. It would be automatic. If you check these boxes, we have to give you it. You can open up your
Yes,
business.
Your Honor. And this is a mechanism that allows the city council to make that decision. And Your Honor, am I thrilled that I have the Planning Commission recommending approval and I'm defending against it? No, I would much rather have it the other way. But does it happen this way? Yes.
All the time.
It does all the time, because the elected officials are in a different position. They have gone through their role is completely different, and their education and their training in terms of the city development and the stewardship that the city council has is different than the planning commission has.
They can't afford, if they want to keep their jobs, to be as objective as the planning commission can.
Your Honor, that's not their, again, it's not their role. Their role has to be subjective. And the other.
Well, I mean, they're the ones who would decide what the standards are, and then they have an entity that says, does this comply with the standards? Yes, that ought to really be all there is, but there is necessarily a subjective gloss that gets put on it through the hurly-burly of the politics, and that's what we have here. I don't think it's more complicated than that, but I also don't know that that's wrong. I'm not saying that that's fatal to the outcome that happened here.
Because otherwise we would just stop at the planning commission, and the planning commission would be the ones to make the final decision.
Which has a lot to be said for it, but it opens it up to scenarios like this, and that's the system that we built. I'm not just that's where we are. I don't know that we need to be as euphemistic about it, but it is what it is.
Thank you, Your Honor. That's all I have at the moment.
Okay. So, Ms. Flaherty, to me, that was a persuasive distinguishing of Raffensperger. Do you want to try to get Raffensperger back on track? Raffensperger is a great case for some of your argument, but I was on the wrong axis as I was looking at it. And I'm confident, having had cases with Ms. Main before, that she will send you and me a bunch of cases that the Court of Appeals or the Supreme Court say separation requirements are okay, exercises of local legislative authority to say you can only have one gas station every 0.5 miles on a street or this or that. And that seems to be the logic behind what was articulated by some of the council members who decided to decline or deny the application. That seems to collide a little bit in an unhelpful way for you with Raffensperger.
Certainly, Your Honor. I'll address those cases first and then Raffensperger.
Okay, I don't have those cases in front of me, so you're not going to be distinguishing a whole lot other than the concept that those cases represent.
Sure. Those cases aren't applicable because we don't have that ordinance here. We don't have that general separation requirement. We've got the city council acting against a single person in a protectionist way. And there could be, if there was an ordinance, there could be a legitimate health and safety reason behind that, which would still have to pass muster under Raffensperger. And what Ms. Main seemed to be arguing was that Raffensperger just doesn't apply to zoning. And I don't think that's the case at all, because it spoke very broadly about the right, the constitutional right that's at stake, and that's the right to earn a living in the occupation of your choice. And the government might interfere with that right through an occupational license. It might interfere with it through zoning. It doesn't matter what the government is doing. It just matters what the right is at stake. The right is at stake.
If there's a health or safety justification like licensing, we want to make sure when you are tweezing eyebrows, you don't stab someone in the eye, so you have to have certain qualifications. That type of interference, it's not the word I would use, I view that as good regulation, but that's something, that burden that it would place on the business owner is something that wouldn't be inconsistent with due process.
Absolutely.
Okay, but if it's more economic based, saying it's not great for the Jack in the Box to have the McDonald's nearby, that's more Jack in the Box's problem than the public saying it would be unsafe to have so much beef in the same 400 square feet.
Exactly, Your Honor. And the Georgia Supreme Court was clear about that protectionism is not a legitimate interest. And I think one of the cases that they cited is instructive, the Moultrie Milk Shed versus Cairo case. And that, while it wasn't about zoning, it was about a geographic restriction on doing business. It was about a milk plant not being able to, only being able to sell their milk locally. And so it was meant to protect local businesses from competition. And the court said that there was no health and safety reason for that, and so it was illegitimate. And Raffensperger relied on that, and that's obviously not an occupational license.
Does there have to be an ordinance in place that imposes separation requirements? If there are cases in Georgia law that have upheld the passage and implementation of separation requirements in a zoning framework in a municipality, then that says to me that the courts have said, you know, there are some non-health and safety rationales that could prevent a business from opening exactly where it wants to because it's too close to another business of the same type. And so if such an ordinance can be passed and it would be lawful, why can't that just be the policy, informal though it may be, of a council member or a council majority?
If those cases exist, Your Honor, Raffensperger overruled them. And here, the city doesn't have that process in place, and there's not that general ordinance. And so, since they're not doing it that way, that in itself doesn't conform to the process.
Okay. Did you have any thoughts about the findings of fact being, hey, whatever was in the record during these two meetings, as opposed to, and it's a fairly crabbed perspective I have, but I envision it has come up recently in cases that we have had in Fulton County involving a different municipality, a much larger one, where the municipality is trying to make someone pay a very large water bill. And there is an appeals process municipally, and ultimately there's something, I'm gonna get the name wrong, but the Water Bill Review Board, and ultimately they say you have to pay the bill. And if you don't like that ruling, it gets appealed to Superior Court. And that has to include findings of fact when they say, here's why you have to approve, why you have to pay the water bill. And it's a report. It's actually something that they have to sign off on. That's not what the ordinance here in South Fulton says, but it just seems a little squirrely to say you can adopt sort of the aura of the findings of fact from the meeting. How is that meaningfully reviewed? I'm sort of making your argument for you, but what is your perspective as to what I may properly rely on in assessing whether there was a factual basis for the denial?
I agree completely, Your Honor, that they haven't made your life easy here and that.
But that's not the standard. That was the standard. Lots of cases would go away.
Certainly, Your Honor. And then this petition for review process is new and perhaps there's not a lot of case law on what the standard exactly is, but I think it's notable that the city's own ordinances say they have to do this and they should be held accountable for that.
Okay. Ms. Main, Raffensperger overruled the separation requirements cases. My guess is you disagree with that.
Your Honor, I have not looked at that case with that eye. And so I'm not, I would like to look at it and disagree with it, but I'm not going to say to the court that, and I think you need to do more than what we're talking about with the case to overrule a whole line of cases, but I would like the opportunity to look.
Okay. Well, I'm guessing, just given, again, where you practice, there's not a footnote in Raffensperger that says, and by the way, all those cases that talked about separation requirements, we hereby overrule them. This would be, if it is, it would be an overruling by implication. If we take the Raffensperger, that's a complicated name to use in connection with this because of all the election stuff. But that case, it sets forth a certain principle, and maybe it's fatal to the separation requirements line of cases. Maybe it's not. You help me appreciate that they aren't head on anyway. There's one that says you can't ply this trade in this community, bless you. And that's not what a separation requirement says. You can do hair braiding, just 2 shopping centers over. Don't do it right here.
Yes, Your Honor. And she can still do hair braiding. So, Your Honor.
In South Fulton,
In South Fulton.
just not in maybe District 3 or that part of District 3.
All I know is not at the location that she applied for, Your Honor. I can't go any further than that. But I also did want to point out 2 things to the court. In the zoning ordinance, and it's in the very first section, it's 103, talks about the purpose.
All right, hold on one sec, because I just have little snippets. Is the zoning ordinance?
It's on the record, page 84.
Okay, the record, this is what you filed today?
I believe this
Oops.
part was filed today. There are 2 different parts of the record, and we
Yeah,
filed.
supplemental record.
I believe that this was part of the supplemental.
Oh, yes, look, here we go. Oh, and is this the constitutional letter you're talking about? Number 9, item 9?
Your Honor.
Where they
it's-
capitalize the mayor's name. He doesn't
It's at
capitalize
the
his
very
name.
end. It is on record 250, page 253.
Yeah, that's what you were referring to as the constitutional, right,
Yes, Your
okay.
Honor.
All right, but you're saying page 84,
84 at the very top of that is what we've been talking about, and there.
designated uses?
No, Your Honor, it is the very top, and it just talks about the purpose of zoning, and I just point out.
Okay, hold on one sec, let me get to it. I had to subtract like 50 something to get to the actual number. 84, comprehensive plan, 103.02.
It's right above that, Your Honor. It's actually starts on the previous.
Oh, purpose, section 103.
Yes, Your Honor. And because we've been saying health and safety, Your Honor, the purpose of the zoning ordinance, there's no problem with this, but the purpose of the zoning ordinance is broader than health and safety.
Prosperity.
Prosperity and general welfare of the city. For facilitating the development of the city in harmony with the comprehensive plan of the city and for purposes described in that's. But Your Honor, so the zoning ordinance itself is more than health and safety. So Your Honor, that is why this, from the city council's perspective, why they would be allowed to do that. Your Honor, I also would like to point the court to just one more element, and it has to do in the staff analysis. Your Honor, there is, and this is at record page 51. There is a study, and this is before it goes to the planning commission.
This is page 51 of the record.
Yes, Your Honor. And it says page 9 of 11 in the staff report. And Your Honor, that is a.
Page 51 of the record. What I've got is it's a picture of 5370 Campbellton Fairburn Road.
Yes, Your Honor, that is the correct page.
Oh.
That is the address of where the salon, the SUP had been. Your Honor, that is a study of all of the other uses that are the similar use in a 1 mile radius. And Your Honor, that was created by staff before it ever went to planning commission and before it ever went to city council. And I only raise that to say that this is not a made up after the fact, let's justify and be protective as to this one salon. Your Honor, this analysis was done by staff to be able to be presented to the city council. So it is an issue that was not made up to protect an existing facility.
When you say issue, though, apparently neither the staff nor the planning commission thought it was an issue. It's data, but that data wasn't something that gave them heartburn. They said,
Yes, Your Honor, that you're correct.
Okay.
And the city council makes its own decision.
they do, they look at the data and they get input from the community in a way that I guess the staff and does the planning commission, is that a situation, if it's in the record, do they have hearings?
Yes, Your Honor.
Okay, so that is just as open to people sharing their thoughts.
Yes, Your Honor.
Okay.
Yes, Your Honor.
So I don't misinterpret page 51 of the record. There's a big blue circle with let me do this. All right, on your screen or in front of you, however you want to do it, is page 51.
Yes, Your
So there's
Honor.
a big blue circle, which is what?
The mile radius.
From that point. So 5370 Campbellton Fairburn Road, a 1 mile radius from there.
Yes, Your Honor.
And that's basically the shopping center we're talking about.
Yes, Your Honor.
So within 1 mile, and then there are these colored dots that are right next to what looks like the center of the circle. But those colored dots aren't looks like there are 4 salons listed.
Yes, Your Honor, and it's not clear to me if they're all located, if those dots are all located in the area.
Okay,
So I can only go by, in terms of the record.
got
I
it.
can only go by the narrative that's underneath that shows the 4.
Within 1 mile, excuse me, of that stake in the ground, obviously Salon Vibes, it's in the same shopping center. There is something listed as a barber shop, Presidential Cuts,
Yes.
a nail salon, so not really the same thing, and then a beauty salon, Styles by LASIN. They didn't seem to be, I guess, quite as concerned about the braiding shop coming in. Maybe there's something in the record, but I only saw things, comments relating to Salon Vibes.
And Your Honor, I don't know whether the other locations, if they had people, they're limited to 10 minutes per side. And so sometimes if there are people who are there, they won't necessarily, I mean, we can't read into that they're in favor of it or not. And I
No.
don't think that there's anything in the record one way or another about those other locations.
Well, what's not in the record is emails from these places. Somehow they're emails from Salon Vibes. I don't know how they got into it, but they're there.
Yes, Your Honor.
So one can read into the record that Styles by Layson didn't send emails in because they're not in the record.
That's as far as I know. Your Honor.
Okay, all right. And at the bottom, it says meeting on June 26th. So that would be the meeting of the planning commission.
Yes, Your
It
Honor.
was done in preparation by the staff for the planning commission meeting of June 26th.
Yes, Your Honor.
Got it. Okay. Thank you. Take that down. Let's pause for a second. Thank you. Mhm. So, Ms. Main, what is it that you think we do next? You find some separation requirement cases, I know that, but what is your proposal? You should affirm the city council because, or send it back for written findings of fact, or what? I know the relief that Ms. Diagne is seeking, and I have very much understood your helpful explanations of how this was working and the city's perspective. But what's your bottom line? Because you were reassuring that, look, we can work this out. That's not the words you use, but the way to address this is through the petition for review. We ought not, and maybe aren't able to, for legal or procedural reasons, to get to the declaratory judgment pieces or the injunctive relief.
Yes, Your Honor, I believe that the court can follow pursuant to the petition for review, can do one of the elements in there. And I would ask that the court either dismiss the appeal, which would let the denial stand, or send it back if the court is concerned about the element of the factual findings, that the court send that back to the city council for those findings.
So dismissing the appeal would mean affirm the city council action?
Yes, Your Honor.
Okay, and that's because what you've pointed out in your reply or your response, I haven't had a chance to read that yet, came in today, but you've been articulating some of it in person, that there was a factual basis for it, that the a concept of a separation requirement and city council members taking in consideration the economic impact of high density of certain retail locations. That's all appropriate. You're not limited only to thinking about health and safety, and that's not the only justification for saying no to a request, et cetera. That taking all that in sum, and the standard of review that I'm to apply in a petition for review of a zoning decision gets one to the point where the correct legal response is to say, basically affirmed to the city council, which would be dismissed to the petition.
Yes, Your Honor, because it's any evidence in the record, and it is admittedly a low threshold for the city to overcome. And it's any evidence in the record, and we believe that there is more than any evidence in the record.
All right. How long are the two YouTubes?
Your Honor,
Well, it's probably the whole meeting.
no, they're painfully long for the court to. One of them, I think, is even like 6 hours or something.
But they're talking about lots of things. It's not just
They are.
Ms. Diagne.
We point you to, and I'm sorry, I don't know if the plaintiff's brief has the time in it too, but we point you to the time sequence and you can go along. And at least the version I have looked at, there is a delay or something between what you see in the screen and the words. So.
But it's figure outable. As long as you've got the timestamps, that's how we have to do. The county commission go on for hours and they talk about the courts just for these 2 minutes. And so we're all jumping to what are they doing? What's our budget? Okay.
And that's that we have both the July 9th meeting, and then that's where they had the hearing, and then they don't vote at that meeting, they vote at the next meeting, and we've got that in the record too, both of them.
Why did they not resolve things in one setting?
That's not what they do.
Okay, so it was on the agenda for discussion and then it comes back for a vote.
That's the way they handle all of their public hearings. They don't vote, then they vote at the next meeting.
Okay. All right. Ms. Flaherty, more you want to tell me about the petition for review, and do you want to talk at all about injunctive relief?
Yes, Your Honor, to both.
Okay.
First, to respond briefly to some of Ms. Main's points. First, to her point that what can still bring, just not exactly here. That's irrelevant because Raffensperger versus Jackson speaks in more general terms than that. And I think the facts of that case are instructive. It was about lactation consultant licenses. And the government maintained throughout that entire case, there was plenty that the lactation consultants could still do without a license. And that included working for the government. And so that's essentially, you can do your entire job just in a different office for a different employer. But the court still thought that the license was interfering with lactation consultants' right to earn a living. So it doesn't have to be a total prohibition in order to violate Raffles Perjury. And second, to the point of notice for preserving our constitutional claims, Ms. May noted that we didn't represent AWA at the time that we sent that letter.
Yeah.
And that's irrelevant. The standard is simply, were they put on notice that there might be constitutional issues with what they were doing? And the answer to that is simply yes.
This is your letter of July 23rd.
That's correct. And that was the morning of the day that they denied her.
Okay. And the letter is entitled Constitutional Concerns Regarding Potential Denial of the SUP Application. Okay, so your position is notice is notice is notice. Don't matter if we were her lawyers at the time or not. You could be a concerned citizen. You could have been whomever. There's an issue with what just happened here. And now the city council and the mayor is aware.
Exactly. And
Okay.
the city attorney responded to the letter as well.
Okay. Mr. Hyman. All right. What about injunctive relief? How would that work?
The interlocutory injunction?
Yeah.
Action.
Not the deck action, but the injunctive relief, because that's where it got particularly muddy, where you acknowledge in some of your pleadings, look, we know you can't try to get an injunction on an interlocutory basis while waiting for the deck action. That's already been decided. If you're pursuing the deck action the way you are, paragraph 5, but there was this, creative is the wrong word. I don't mean that anyone's stretching any envelope. It's just we're operating in two intersecting spaces because there's a petition for review. And in many ways, your client checks the boxes for an interlocutory injunction about the harm, and the city's going to survive just fine if, while we're working through this, she's able to open up the business that she's already leasing. And so why not? It's not quite the status quo, however, because an injunction preserves the status quo, and the status quo is that the permit was denied.
The Green Bull Partners case from the Georgia Supreme Court points out that an injunction doesn't necessarily have to preserve the status quo. It is really more about preserving the case. It's about making sure that bringing the case wasn't pointless to begin with, because we're here fighting over a space and she loses her lease. And that's the Green Bull Partners case that we cite in our briefing.
Okay.
And as to why we asked for the interlocutory injunction, that's what one would normally do when you're seeking relief on a timely basis. But as Your Honor has acknowledged, we've got a lot of new procedures and new law floating around here. And so we wanted to cover all our bases. And the only reason we would need an interlocutory injunction right now is if Your Honor believes that it's not time to decide the petition for review claim. And so the injunction would obviously be unnecessary. The only reason we wanted is if this was going to go on for some time.
Okay. All right. Anything else you want to add?
Your Honor, Ms. Main spoke of the zoning code having more purposes than health and safety. Your Honor noted prosperity.
That was one of the words. I didn't make it up. That's one of the words in there.
Sure.
It was a healthy list, but I thought prosperity. That's a great goal. We all want to be prosperous, including, I'm sure, Ms. Diagne.
Right. Is denying always a permit reasonably necessary to further the prosperity of the city of South Bend? That's what it would have to be under Raffensperger versus Johnson. And it's not. It's reasonably necessary to protect salon products from competition. And the record as a whole, and this goes to the petition for review claim, the record as a whole supports that was the reason why. It's crystal clear from the entire record. There's nothing in there to support denying her permit for any other reason.
All right. Thank you. Ms. Main, if the way this plays out is that I decide I need more clarity from the city council about why they voted the way they voted, I don't mean each person filing an affidavit, but how about those findings of fact? What's a time frame for that? Because that's a sensitive issue here, how long it would take. If I'm denying the petition, you don't need to worry about findings of fact, and that may spawn other litigation, and we'll work through it. It'd be related, it'd probably come to me. But if I feel like I can't make a meaningful ruling, then that's probably a send back. But my preference would be to send back with a super short fuse. But I also appreciate the separation of powers, and I'm not the city council's boss by any stretch of the imagination. How, in your experience, not necessarily with this municipality, although you may have experience with this municipality, how quickly do those kinds of things get turned around?
Your Honor, I don't know, because those kinds of things, I've never done that with any other municipality or with this one. I know that and I don't know whether they'd have to do it in a meeting, Your Honor. So I can get the answer to that and let the court know that when I answer the rest of these questions. And by, Tuesday.
Okay.
If that would be okay with the court.
That's the next business day. That's a very reasonable response. So that's fine. That would be helpful to understand. Because if the answer is 90 days, then I do become the city council's boss, and it would be a number less than 90. But I want to see if that's the direction I'm going, what that landscape looks like.
Your Honor, and I will get that answer to you on Tuesday.
Okay. I want to make sure if I have other questions, we've worked through them now, so I don't have to drag you all back here. Is it the case, Ms. Main, as best you understand it, that there is not a separation requirement ordinance on the books in South Fulton, at least not for businesses for which that are classified as beauty salons?
Correct, Your Honor. I don't know if remember if there is for any of the other uses, but there is not for beauty salons.
Okay. So it would be a factor that you would be arguing is appropriate for the city council to consider a separation requirement. It's just not one to which a city council member could point, oh, that's 5-103.
There is not an objective separation number in the ordinance.
Okay. Got it. All right. I think that's it. Ms. Flaherty, anything else you want to make sure I hear from you and your team?
Yes, I don't think there's any reason to remand for findings of fact and to allow the city council to basically paper over what it's already clear has been done
It
here.
was a risk. I mean, I get that. I know I keep interrupting you, but there is always that risk. And magically, that's what happens with these water bill appeals when you didn't make any findings of fact that the meter was broken. You're just assuming that the meter was broken. Or wasn't broken, and so they're liable for the bill. And magically, the findings of fact come back, and they say, "We find that the meter wasn't broken," and then the record is made, and they can say, "See, this is what we relied on to reach our conclusion that they need to pay the bill, or that the permit should be denied."
There's no reason to do that, Your Honor, but if that is what the court does, we ask that you issue the interlocutory injunction. So that AWA can get her business started. And the reason that we can do that with the petition for review claim is that we're not proceeding under that constitutional amendment, and sovereign wouldn't block it there. We're proceeding under the waiver in chapter 36 of the code.
if it's in the record, answer this question, please. It was somewhere because I read it, I think. Ms. Diagne, she is paying a lease and is ready to roll, but for the permit, or if for some reason there was a revote next week and it was 4-3 in the other direction, she still need to do 6 months of ramp up time before she could open her business.
Oh, no, she'd be able to open immediately.
Okay. So it's the lack of the permit and her belief that a permit is necessary that is preventing her from operating in the space she's paying for.
That's correct.
If I were to go to this shopping center this weekend, and I promise I won't, is there a place that says Awa Braids? Like there's a sign there, but it says closed on it, or it says Fred's Sub Shop because she hasn't painted over it yet because she didn't get her permit.
So it's actually both, Your Honor. She has this Agua Best Grade sign, but the sign for the previous business is also still there. And this is not, and none of this is in the record, but she has been renovating the store to try to set up a jewelry store because she doesn't need a special use permit for that.
As a fallback.
As a fallback.
Okay. All right.
But she could still break that space.
Right now it's dead space for the city, not great for economic development, just sitting there empty either.
That's correct, Your Honor. And the landlord is eager to get it up and running too.
Although the landlord's getting paid.
Yes, Your Honor.
Okay. But the landlord for the whole mall, I guess, would like to have activity in all of the units rather than just some.
Exactly.
Okay. This is interesting. Ms. Nain, normally I give the plaintiff petitioner the final word, but again, you had to come in here on short notice. Not that there was any more notice for plaintiff, but plaintiff filed this action, helped impress upon me the urgency of it, and then all of a sudden, here you are. Anything more you want to add before we wrap up?
No, Your Honor, I will just address, I have a list of things that I was going to address for the court.
Yeah, let's make sure it's a comprehensive list.
So, okay. Cases about separation of uses. And whether Raffensperger overrules by implication.
You don't need to, I'm just asking your thoughts on that. You don't need to respond. I will read it more fully. I became very interested in it once it was cited for two reasons. One, I think it does relate to this case, but two, it's a case that's not about elections. And as I've already said, like, wow, this is great. It has nothing to do with hand counting of ballots or anything. So I was happy for him.
Oh, we're all very happy about that.
Yeah.
And Your Honor, well, if I can't help myself, because I mean, it raises a question for me too.
Sure.
So
you're welcome to opine on that if you want.
if I feel like, yes. And then what would the city council need to do if the court were to send it back?
It's not so much what they need to do, is how, if it were sent back because there is an inadequate record, i.e. no findings of fact, how soon do we get those back?
Yes, Your Honor, and that was part of the first thing I have to find out is whether they need to do it at a public meeting or if they need to have a vote or how they need to do it, and then the timing of it. Your Honor, that was my list.
Okay, I agree. And obviously whatever you send to Ms. Niles, send to Ms. Flaherty et al.
Yes, Your Honor.
And you're free to respond. No one needs to do fancy briefing. I mean, what is 100% okay is, hey, Ms. Niles, here are 3 cases, and the city council would be able to get findings of fact back to everyone in 19 days. That is P.S. I don't think Raffensperger over. I mean, you do whatever you want with that. That is fine. Doesn't need to be a 9-page letter on fancy letterhead. If you want to do that, that's great. I just want the cases and the answer. And you're free to respond if you say, those are fascinating cases, here's why they don't apply anymore, or if you want to do something like that, you're welcome to. It'll just get me heading in a helpful direction. All All right. Well, I appreciate everyone being here on a Friday. And I will take this under advisement. I very much appreciate that it is time sensitive for Ms. Diagne. And she is entitled to an answer, whether it's one that brings happiness or disappointment, but at least an answer so she knows which way to pivot, jewelry or braiding, at least temporarily. And then she can chart a different course if the answer is jewelry for now. And we'll take it from there. Thank you, everyone.
Thank you, Your Honor.
And I don't know who all requested the court reporter, but if it's both sides, just make sure you settle up with the court reporter. Thanks.
Thank you, Your Honor.
Brandon, what are we gonna owe you? Or will you bill us?
I believe an email will be sent out.
Okay.
Thank you so much.